motion to admit DNA results prior to the defense concluding its presentation. By the way, I did want to mention something before I got to that, and that is, earlier in the trial, there were questions that were asked of a witness or witnesses relative to a report of some sort related to the Honolulu Police Department crime lab. And I had mentioned at the time that the witness was subject to recall, and that was at a bench conference. And I wanted, what I wanted to do was look at that report, because the apparent allegation was that it would rebut what the witness had said about the lab. Although it was also represented to the court that while the witness was testifying, there was a quick research done. I'm not saying that word quick research or words quick research were used, but in any rate, while the witness was testifying, there was some research done by Mr. Nardi, I believe, and he found this report on the HVD crime lab while apparently over the internet. I'm not sure of that. So I did want to take a look at that to assess whether that's something that the court should consider, unless the defense has decided for other reasons that that's something that the defense is not interested in pursuing. So I'll just mention that, just so the parties are aware of that request. Now, before the court today is the state of Hawaii's motion to admit DNA results. And more specifically, the state of Hawaii is requesting that the court admit DNA results to rebut the testimony of Dr. Laufer, who testified as a defense witness during the trial. The state argues that the defense opened the door to the introduction of the DNA evidence, and the DNA evidence we're talking about would be the Sorensen and FBI DNA evidence. That evidence, that the testimony of the Dr. Laufer is such that the door was open to having that evidence from those labs presented. And here the prosecution has argued that the door has been opened the state of Hawaii has argued in support of his motion that the evidence is probative concerning the identity of the wearer of the blue jeans, and that the testimony of Dr. Laufer would leave the trier of fact with incomplete information regarding the evidence gained through the course of the investigation of this case, and allows the defense to put the state at an unfair disadvantage. It is argued in part by the state that the defense, having elicited testimony in the form of a medical expert opinion that the blue jeans were worn by a woman, not a man, if uncontradicted, would allow the defense to perpetrate a fraud upon the court and mislead the trier of fact. And so no, I asked the state to allow me to, or to inform the court of specifically what the experts said that would open the door to the DNA evidence. And I was referred to page 63 of the transcript that I previously referred to, lines 13 through 16. That's a question by Mr. Nardi. Okay. It reads, okay, in your own work and interest in understanding mechanisms of injury and pathology, do you also have occasion to study the clothing people who are injured wear? And then the court was pointed to, or directed to page 68 of the same transcript, beginning at line 10. And what occurred there was this question by Mr. Nardi. It reads, I may now direct you, while we're still on this photograph, is there anything that you would expect to see that you don't see in this picture if these were worn by somebody committing a murder with a knife? And then the answer of the witness was, so when you see clothing that's worn during the commission of a bleeding event, murder, assault, battery, etc., and people get blood on their hands usually go to various places, and those places are most commonly around the pockets. So any of us who have fixed a car or whatever and had grease on our hands know that we get grease around the pockets too, because that's the common place for the hands to go. And there's no blood around the pockets. Question. Okay, and do you have an opinion with regards to whether or not those jeans were worn by what sex person these jeans were worn by? Answer. So you can see that there's a button that goes into this buttonhole over here on the right side. That's consistent with male jeans. Question. Okay, is there anything with regards to the wear patterns you see? Answer. Yeah. So it's kind of curious. Usually in jeans, especially if you've worn them enough to get those sort of crease marks here and here on both lateral sides of the leg, you would expect some crease marks around the crotch as well. And there aren't any. So, question, you would expect some marks around the crotch mark if they're worn by who? Answer, by a male. Question, what about if they were worn by a female? Answer, then you don't have the same thing sort of pressing this tissue, this cloth out. And so you're less likely to have those kind of crotch marks. Question, okay, so am I understanding you correctly that when jeans are worn by a male, you can expect some additional, would it be wrinkling? Answer, sure. Question, okay, and again, where would that wrinkling take place? Answer, usually around this area and some going up to the bottom part of the fly area. Question, okay, and what about the male anatomy in contrast to the female anatomy causes all kinds of additional wrinkles if these were worn by a male? Answer, yeah. So you'd have the penis, and really it's the penis that sort of projects outward, creating an area kind of bulging around the fly. Question, okay. And in addition to your training in medicine and in inventions and everything, do you have any other experience with clothing to kind of help direct your opinion on this? Answer, yeah. My family was in the dry cleaning business, so for the first 20 plus years of my life, I spent my time cleaning clothes and spotting clothes and steaming clothes and pressing clothes. And question, okay. Now again, going back to that picture, well, let me also go to states. I'll show you, I want to publish, Mr. Nardi, permission to publish states 263 The court granted by Mr. Nardi. And does that appear to be the backside of those jeans? Answered yes. Question, and again, would you agree that the mark down on the bottom of the left side of the left pant leg also appears to be consistent with a blood stain? Answer, it certainly is yes. Question, okay. Now looking at those blood stains together, and again, if you were informed that those jeans are being part of a murder investigation, what, if anything, do you find significant regarding the size of those blood stains? Answer, it's not a whole lot of blood. You know, the stain on the left that we're looking at now in the back of the jeans is less than 4 or 5 cc's of blood. The stain that was on the right front is at most 8 to 10 cc's of blood. If you were talking about someone who was stabbed, you would expect liters of blood, so thousands of cc's of blood, and there would be a lot more than we're seeing here. Question, and okay, and is there anything else in this picture, again, that from a forensic pathology's point of view, that you find significant? Answer, well, I mean, the size is always significant. Question, the size? Answer, and at least by the label, these are 32/30. So a 32 waist, 30 length, which typically would fit somebody who was 5'9", 5'10" in height. What's interesting is that the bottom of these jeans are sort of ragged, being stepped on by the shoes, and so it suggests that whoever was wearing these jeans was shorter than having an inseam of 30 inches. And that ends on page 72 of the transcript, line 3, which is the last line that the prosecution relies on. And so the prosecution submits that those questions and answers opens the door to the DNA evidence. The areas covered by the witness related to the expectation that there would be some blood around the pockets, that the buttonhole was consistent with male jeans, that the pattern, or that with respect to the patterns on the jeans, there was a lack of crease marks around the crotch that you would typically see if worn by a male, that the size of the blood stains are not consistent with the, in other words, the volume of blood was smaller in relation to what one would see with this type of a alleged offense, that the size of the jeans would be consistent with someone who was about 5'9" or 5'10" in height, and that the wearing pattern on the legs, because they're ragged, would suggest that whoever was wearing the jeans was shorter than an inseam of 30 inches. The testimony of the expert then, in one part, was that the type of jeans was consistent with male jeans, and in others that the volume of blood, lack of blood stains around the pockets, were not consistent with them having been used in the homicide, and that the wear patterns, crease patterns of the jeans suggest that the jeans are not being used by a male, and that, as I've already mentioned, the issue related to size. In the court's view, these questions and answers do not open the door to the DNA evidence. These statements by the witness, in part, what the witness says suggests certain results, and also actually point in two different directions, one to being male genes and the other to not being used by a male. The others are not really pertinent to whether it was a male or female. It's just a question of whether it was used at the time of the homicide. In terms of volume of blood and lack of blood around the pockets. That, in the court's view, does not open the door to the DNA evidence in question. And the court, in order to the court is under an obligation to carefully examine any rebuttal evidence that is offered by either side, and to make sure that it indeed rebuts what's been presented. While I can appreciate that the prosecution's desire to present this evidence, really, if you're talking about rebutting it, it would be someone who would be testifying concerning the size of the genes, the length of the inseam as it relates to the height of someone who used them, someone who would testify as to the wear pattern, the lack or presence of crease, and whether that's indeed indicative of male versus female use. The volume of blood, the location of the blood stains, could all open the door to evidence by witnesses trained in that field, in those fields, I should say, but not in terms of DNA evidence. So I do not see this as rebutting what the witness has said. What the prosecution wants to present is evidence of a blood stain that would be consistent with the defendant's blood. At least that's what the motion presents. And that's not proper rebuttal here. And if the court were to permit that, and the defendant were to be found guilty of committing the homicide, then in the court's view, that would not survive appellate review. The DNA has come up on more than one occasion in this case, and today the argument in part was that the government should not be relieved of the sanctions that the court imposed. I do want to just touch upon that because it was argued by both parties. Although no order has been submitted by either party relative to that motion, the circumstance or the background to that particular issue was that it had been, from the very beginning, the very first pretrial that occurred more than 2 years before this case proceeded to trial, actually about 2.5 years prior, at least approximately 2.5 years prior to the commencement of trial. It was discussed and disclosed by the prosecution that there would be DNA evidence. And the court, having had experience with that, expressed a concern then and throughout the 2.5 years that followed, the importance of making sure that evidence was, and that work was concluded in a timely manner so it could be turned over to the defense, and the defense would have the opportunity to do its own workup on DNA. That is very typical in a case where there's DNA evidence. The court handled or conducted pre-trials in this case. Either twice every 4 weeks or once every 4 weeks, depending on the time period that we were in, meaning that the court conducted many pre-trial conferences, and as the parties know, one of the court's first inquiries was where do we stand on the DNA evidence, because the court was concerned about that, and I wanted to make sure that when the case was ready to proceed to trial, that everything was in place so that both sides would be prepared for trial. And I did ask on numerous occasions that the prosecution, in fact, I made specific requests of both Mr. Rivera and Ms. Jones at different times that they call the labs involved, and initially it was the HPD lab, explaining to them that the case was going to go to trial and the work needed to be completed as soon as possible. And the prosecution represented to the court that they did make the lab aware of that. And when there was a continuance granted, the request of the prosecution at the time when the prosecution said the case had to go to trial in January, that the prosecution would have to be seeking a new indictment anyway, so the case would not be proceeding to trial in January. The court at that time set up yet a schedule for the completion of the DNA work that was going to be done by a lab other than Sorensen, and it was going to be another lab initially, then it went to Sorensen, and also the FBI, stressing the importance of getting that done quickly so that we didn't have a large volume of discovery presented to the defense on the eve of trial. And I brought this up many, many times throughout the 2.5 year period. I know to the point where the parties were tired of hearing me say it. But experience taught me that that was of critical importance if this was going to get done the right way. I'm not blaming anyone for it. The way it unfolded, that's not the point here. As they say in today's world, it is what it is. And what happened here was days before the commencement of trial, literally hundreds of pages of discovery were provided to the defense dealing with DNA testing and results. Put this to the backdrop that there's about a 2.5 year period when the prosecution was working up this evidence, and the defense was then going to be asked to do their work up in a matter of days or weeks. That is, on appellate review, is doomed to failure. So, at the time, when I was presented with the question of whether or not the particular DNA results, and the DNA results of the focus of the motion were the Sorensen and FBI results that had been provided days before the trial, I simply could not, as a trial judge, allow the 2.5 year period to develop with respect. Actually, it was longer than 2.5 years because, but I'm talking about from the time that I started meeting in pre-trial conferences with these attorneys, before review, and through the time of commencement defense on trial, and it would make no sense. The prosecution have needed 2.5+ years to put their DNA evidence together, and then to expect the defense in a matter of days to do the same thing. It's just not realistic. And as I mentioned when I ruled on it originally, that's just one half of the equation. That's the part where the defense would be reacting to the prosecution's presentation. That doesn't even get into the next phase, which is the defense wanting to conduct its own testing, which would have been extremely lengthy. It's just completely unrealistic and would lead to a reversal of any conviction obtained in the court's view if the court would have allowed it to have been presented. I did not present it in relation to a sanction. It was just in terms of the timing of the discovery. The court had no alternative but to not allow those results presented on the eve of trial to be used at trial, especially considering the fact that it had taken some 2.5 years for that, plus years, to have developed. That would lead to a reversal of any conviction in the court's view, because it would lead to a denial of the defendant's right to a fair trial. So today's arguments related to a part by the defense were that the court had sanctioned the prosecution, excluded this evidence, punished them by excluding the evidence, and that the court should not undo that or provide any advantage to the prosecution. The prosecution's argued that it was not in the form of a sanction, and I wanted to provide the background because what occurred here was that I was viewing this in terms of the defendant's right to a fair trial, and in the court's view that led to one result and one result only, and that is if it takes one side 2.5 years to develop the evidence, how can it realistically expect the other side to, number one, contradict that evidence if they can, and number two, to do their own testing within a matter of days or weeks? It's just wholly unrealistic, and it's not the way our laws work, and it would be, as I say, doomed to reversal of any conviction that might be obtained. So I didn't do it in the form of a sanction, but in terms of the timing of the discovery and and protecting the defendant's right to a fair trial. And I guess if it ever becomes relevant, if there were to be another trial in this case, this ruling was not intended to exclude evidence of any trial that might occur in the future, because I do understand that there is a conviction. It's a virtual certainty that there will be an appeal from that conviction, or there could be the inability of the jury to reach a verdict. And so this ruling is not intended to exclude that evidence for all time, because if there were to be another trial, that would result in providing adequate time for the defense to do their workup and to be fully ready for the testimony related to Sorensen and the FBI. And so I thought it important to clear the record up. All right. But when you look at the specific testimony, as it relates to today's motion, did Dr. Lawford's testimony open the door to the DNA evidence? And when I look at exactly what he said at trial, some of which actually is consistent with the prosecution's theory, that there are male genes, and some of which is consistent with the defense theory, none of those specific items opens the door to the DNA workup. And so I'm going to deny the prosecution's motion to admit DNA results. Mr. Now, I did ask about that article you folks referred to that you said you found during examination of the witness.
Yes, Your Honor. And I understand what the court is referring to. We have no intent to pursue that line.
All right, so that's a closed matter.
It's a closed issue at this point.
Okay, all right. Okay, then,
So I have to apologize, Your Honor. We just realized that there is a mistake in the printout that we were proposing as our defense. And it asks, we printed out the data section rather than the voice section. I have a section that we may be able to use with the court's assistance, and that assumes that if we make the copy, any yellow will not show up. So this is what we're trying to introduce. The unfortunate thing is I have yellow markings on it. If we can make this copy without the yellow markings,
we may be able to. Let's try that right now.
this would work.
Let's give it to the bailiff will attempt to assist us on that. Let's see if we can get
Hopefully that works. Otherwise, we'll have to ask to reprint, an opportunity to reprint.
Yeah, we'll see. We'll see. It may be that when we photocopy it, it'll come up. And then why don't we just make that photocopy, then the prosecution can look at it. That way you'll know about the quality, and defense can do the same. Let's do that right now.
Your Honor, may I just address one matter relative to the court's ruling? And by all accounts, we appreciate the court's ruling, but my fear is that perhaps the court threw out some dicta out there which will prompt the state to attempt to bring in rebuttal witnesses on those areas that the state or that the court made reference to. For example, the patterns are the size of the blood stains, the size of the genes. In its ruling, the court, and I don't know if the court was ruling specifically or whether it was dicta in terms of that being subject to rebuttal and that those areas were opened, those doors were opened in that area. I would respectfully submit that that should not be the ruling, that based on the case law submitted in our memorandum, in terms of the state's obligations in its case in chief, that even in those areas, for example, in the size of the genes, it's the state's inherent affirmative duty in their case in chief. If that's their theory, that Mr. Capobianco was wearing those genes, it's their duty to present that in their case in chief.
Well, you know what? We could have this discussion about everything that was presented during your case. And this discussion could go on for, I appreciate that I did, you know, bottom line is, when we get to rebuttal, if that's what's going to be presented, apparently that's what's going to happen, you're probably, I would suspect that there will be discussion about some or all of the rebuttal witnesses, and we'll just deal with those. I have no idea what the prosecution is planning on. Maybe you do know that, but at any rate, we'll get to that when we get to it. All right. Would you folks look at that exhibit, please, and tell me? Does the quality of that work with defense?
Yes.
Okay, does the highlighting even show up? Because yellow typically doesn't show up.
So if that passes muster of the state, that's what we'd be putting in.
Judge, yes, with respect to these records, as long as the defense is not going to be bringing these records in to discuss location of a cell phone, which would require an expert to do an analysis on. Because this is a data that was provided, or the information that was provided to our special agent Michael Lisa on the phone records.
My understanding is it's in relation to time, date and time.
In terms of when calls were
There is no evidence being presented, as I understand it, with respect to location, correct?
I agree with what Mr. Rivera has suggested, and I agree with those parameters.
All right, so that's the date and time. The phone number is clearly noted on the records, because we've had testimony about her phone number, so that would be the link.
And Judge, what is on this, is entitled, the top title is mobility usage. It does show cell locations and numbers. I mean, that the state would...
Why don't you just agree to have that redacted from the exhibit, and the exhibit would be without the location and other, because we have nothing, no testimony on that.
The last thing the state would want is the jury for themselves to speculate on the locations and numbers and on their own, so they don't have that.
I understand.
They want from us. And we have no objection otherwise.
So, yeah, you know, we are gonna, we don't agree to redact it. I don't see any,
What would be the relevance of it if you don't intend to argue it? Unless you want the jury to go into the jury room during deliberations and start doing their own their own review and determination of location, which of course would be, in my view, would be improper.
okay, so,
What would be the
well,
relevance?
here's, okay, in all candor, you know, what we are, part and parcel of what we're proposing is not only whether this record corroborates or dispels the witness's testimony as to where she was at a particular time on the 13th.
Not where she was, but
When she was out at NB.
when she was making calls.
Well, this goes out, this is, you know, to the extent that she put herself out in NB from a certain time of
Right.
the day,
Yeah, exactly.
these phone records go towards that.
Right.
But one other thing that it does go to, and this anticipates an argument by the state, is that it does make reference to the cell tower locations that are being accessed by her phone at that point in time. And in as much as the state may try to make an argument that, oh, if the phone records show that it was hitting a tower, this particular tower, he must have been out in N-Bay. Well, we believe that these records show that it hits that tower on 5003 at a time when she says she's not at N-Bay.
So your actual offer for this evidence goes beyond date and time.
I guess it does, yes, but it doesn't go towards necessitating an expert like Michael Easter to lay any particular foundation or give any testimony to propose a theory on our part. We would just be using the data on here to dispel the state's argument on the same topic. So I don't see why it's not fair game. I think it is probative, it's relevant, and I don't see any reason for exclusion.
Mr. River.
You know, this is where the state will strongly object. This is exactly what the state, I guess, what was going to take a strong stance of not letting happen is people come and speculate as to where the cell towers were, why certain cell towers weren't being hit, or why they were being missed, the directions of it. I mean, this all requires expert testimony. And to expect or to allow counsel to first make an argument about that when he himself is not an expert and has produced no testimony that's qualified to render that argument or opinion, and to have that put in front of the jury would be completely and wholly improper. That is complete speculation. There's absolutely no foundation for that. If they wanted to address that, they could have done that instead of waiting now, hoping to bring it in through, I guess, a layperson's argument and have the jury speculate and do something that it takes a specialist to do. And Special Agent Michael Easter has already testified to his training, his daily experience, his certifications, and what he does as an instructor. And to think that the juror, the layperson, as well as Mr. Poe himself, can go and start arguing that and talk about locations and why certain cell towers may be hit or may be missed, and whether there's any inconsistencies, is completely inappropriate, and there's absolutely no foundation for that.
The foundation was laid by their expert. If their expert provided testimony saying, oh, if it hits the tower ending 5-1, he must have been out in N-Bay, but these business records show that relative to 5003, it's hitting 5-1 and they're not in N-Bay, that's probative of the credibility and the weight to be put on Michael Easter's testimony. But above and beyond that, to address what the state's saying, my foundation is their expert. I'm not saying anything different from what their expert would say in terms of hitting that tower ending 5-1, except other than to disagree. That he's, or to make the argument that he's wrong. These are business records. He wants to tamper with the business record now just so that he can get the jury to see things the way he wants them to see them. We got an agreement from him that he wasn't going to oppose this. That's the only reason we didn't take this last week to go get a custodian of records.
Just talk about the pot calling kettle black. Counsel just misrepresented himself to the court by saying they just want time and date. And they said they weren't interested in location. Now, when the court pressed them, that's exactly what they want this for, location. And Michael Easter was precluded from testifying to anything after February 12th. This is February 13th. Those records were precluded. He didn't even testify regarding this cell number. And so to think that counsel can argue a completely different cell number and a date beyond, which Special Agent Easter was precluded from going into because they didn't have the records at that time, that's completely inappropriate.
All right. With respect to Defendant's Exhibit S, it appears that the parties have reached an agreement that as it relates to date, time, phone number, that can be received by the court without need for a witness to authenticate those records. The argument here is that the location and cell tower should also be part of that, part of the evidence. Obviously, minutes ago, it was represented to the court that this was used, it was going to be solely restricted to date and time. The defense has now added another element to that, and that is location and cell tower. It would have been helpful to the court had the court been informed ahead of time that that was the intent of the defense, so I could have considered that issue. But at any rate,
Judge, I just need to put the backdrop. The backdrop is that last week Mr. Rivera agreed to let this in without conditions. That's the backdrop, and he can't deny that.
Judge, we didn't expect counsel to act as an expert himself and to argue things that were precluded from our own expert.
all right. Well, at any rate, the location and cell tower that would be involved here, it's not. If I understood the Special Agent Easter's testimony, it's not simply that data alone that is the final determining factor. You have to look at the type of instrument involved, the type of technology that's in that, because the two towers in question, assuming that two towers are involved in these particular records, two towers in question are different with respect to their technology, and the phone instruments are different as well with respect to their technology. Special Agent Easter testified about the different technology involved and the significance of a call being drawn to one tower with and a phone with LG. I'm not sure if I'm using the right terminology because this is all just being presented to the court now. But what I recall is LG 2 versus 3 technology. He has not looked at these records. He has not determined the kind of instrument involved as to a failure Weiss's instrument. I don't recall Major Weiss having the expertise to testify about the type of instrument she used. And that's significant in relation to the type of tower it's going to be drawn to, because I understand it, the LG3 level is drawn to an LG3.
Just so you know, LG is a brand.
Yeah, no, I understand life is good or something like that, but whatever that terminology is, there's a 3 and a 2 that was discussed during the testimony, and he did testify about its significance in terms of what tower would be drawn to when a call is made, and we don't have any of that on the record. We have no expertise, no expert opinion relative to this phone number, the instrument, the type of instrument used. Special Agent Easter's testimony involved 2 other phone numbers and a review of his of the information provided relative to those two phone numbers. I'm not of the view that there's an adequate foundation on the record with respect to this particular phone instrument, considering the type of analysis and expertise that would be required to reach an opinion. I will not be able to allow argument concerning cell tower location and location and cell tower with respect to these phone records, given the record of this trial. So I'm willing to.
Your Honor, may I just ask the court to evaluate that a little deeper? Because really, in the alternative, what the court has apparently considered suffice for the foundation of every other, for the admission of every other phone detail record in this case, is a custodian of record saying this is a business record. It's not like Mr. Easter came in and analyzed every coordinate on every page. It was allowed in as a business record in whole. And then we get to play with the testimony of Michael Easter and let the jury weigh whether his testimony jives with the evidence or whether the evidence jives with his testimony. That's a jury question. This is just a business record we're trying to bring in. I don't see where all that analysis comes in when the alternative would be we just bring in the Verizon lady or the AT&T lady and say, is this in your custody? Are you the custodian of records? Okay, it comes in. Which is, in effect, the agreement, the stipulation which we got from Mr. Rivera to avoid that. So this is just merely a business record. Every argument we make upon it would be based on the testimony of Michael Easter.
But Michael Easter's testimony, in part, was based on the type of instruments used.
As the court may recall, I used that as a basis for objection many times when the state tried to bring in different phone records, and I'm up there arguing, we don't even know what kind of phone they're talking about. We don't know whether it's 2G, 3G, and the state received it as probative over objection. This is the same, we're at the same thing. Except the court is now twisting it against me.
I'm not trying to twist anything, I'm just trying to deal with the record. Bearing in mind that minutes ago, Mr. Upwell, you told me that you wanted this only for date and time, and now you're telling me you want it for something else. And if you brought this to my attention before, we wouldn't be having this discussion today, and none of this, you would have known ahead of time where I would have stood on all of this. So please, I mean, you made a representation to this court. I relied on that representation.
And frankly, I may not have been complete, and it's because there's a lot of things going on here today. But, you know,
that's significant.
To ignore the whole picture here, that this is merely a business record that the state is now trying to alter to their liking by redacting things, when they got all of their other business records in, it is, you want to talk about perpetuating a fraud to the jury, that's what we're doing here.
All right. At any rate, the court has ruled on it, and in this particular instance, Special Agent Easter has not examined anything with respect to this phone instrument or this, the technology involved with the instrument or the records in question.
Well, Your Honor, and the state knows this. That is not true. Michael Easter did a workup on 5003.
Well, it wasn't presented. It's not part of the record on this trial.
All we're asking is for the state to recognize, stipulate its previously given agreement that it would allow in the business records. It has somehow taken a twist into minutia where it's now focused on why we're bringing it in, because they want to now choose or second guess their decision to stipulate to it. But we relied to our detriment on that agreement. And if we need a continuance to bring in the AT&T lady now to bring this in as a business record, that's what we'd be asking if the court's going to rule that this is excluded by, or the state's revoking its stipulation.
Judge, first of all, there was
But the records that are in relation to what Special Agent Easter has reported on and testified to. These records, he has not provided any testimony about these records. And nor any testimony about the technology involved. The jury would be left to go into the jury room and listening to arguments of counsel, I guess acting as expert.
I disagree with that. I'd be using Michael Easter's words as an expert.
No, he wouldn't, because he hasn't reviewed any of these records. And he doesn't know the technology involved in the phone instrument. So, and please understand that minutes ago you told me you wanted this solely for date and time. That's what you told me. And so, you're now expanding it, and the prosecution saying if you're going to expand it to that, they're not agreeing. And I can fully understand that.
They should have told us that last week. They should have asked that last week.
That would have made no difference. We still would object to this. We would still have the objection if counsel is going to act as interpreter.
Well, you know what you're telling me then is that you knew last week you were going to use it for location and cell tower. Then the representation you made to the court just minutes ago was false. And I know you're not saying that. I'm not trying to say you're making a false statement to the court.
Maybe it was false, but it's not advert. It was not purposeful. I got a lot of things that I'm arguing here today. This one was one of last moment, unexpected things that, frankly, I'm not sure would have been an issue if we had the hard copy ready to go at the beginning of the day, because the state again agreed that they weren't going to oppose it. So,
Well, anyway.
It's just this to me. This is just a matter of state revoking its agreement, and if that's the case, just say it. I mean, don't act like you're now out legal arguing us. It's just you
At best, there's
revoking your agreement.
At best, there's no meeting of the minds, because if you intended to use it for location and cell tower and they intended to go date and time only, then there's no meeting of the minds here. That's best case scenario. The other would be if, well, we don't want to, I don't want to go there, but you did make representations to the court minutes ago about what you intended to use this evidence for. So, and now you're asking for more than that, and respectfully, I'm ruling that that would not be proper. So there's no objection to allowing in phone number, date, and time. And so if you want that portion admitted, then they're not objecting to it, and you just have to let me know. That's defendant's S, marked for identification purposes. But I'll have to be redacted to remove the cell tower and location information. Because I do want to bring the jury in, so I need to know.
Oh, you're asking for that now? Yeah, I guess that's our intent, but we need to redact it.
Okay, then when I say defendant's exhibit S is received in evidence, it'll be a redacted version of it, excluding the location and cell tower.
Yes, sir.
Thank you.
So that'll need to be presented to the court. Okay, I think then we are ready for the jury. parties and the defendant, ladies and gentlemen, this morning, so you may be seated. Thank you. And the record will reflect the presence of the members of the jury. And so at this time, Mr. Elko.
Thank you, Your Honor. I just have a couple of matters to take care of. At this time, I'm showing the state a copy of what is marked and identified as Defense Exhibit G. At this time, I would like to move this into evidence.
Mr.
No objection, Your
Rivera.
Honor. No objection.
Defendant's Exhibit G, marked for identification purposes, is received.
It's permission to publish.
Granted.
Actually, let me get the other.
Do we, by any chance, do we have that so that can be published at one time, electronically?
I'm just going to hold it up, actually.
Okay, all right, we can just walk in front of the jury with it.
Again, sorry. This will be in evidence.
All right, the record reflect that the exhibit has been published.
This time, Your Honor, state copy, or what is actually marked and identified as Defense Exhibit S. It is an 8-page, a copy of 8 pages. On the condition that that be redacted as ordered by the court,
Give them a chance to review it, please.
Your Honor, really?
You may.
exhibit.
Yeah.
We would be moving.
So what you have to correct what was initially presented to the prosecution, and now you have the right item
Yes.
attached. Okay. And based on that, and the court's earlier ruling, the defendant's exhibit S, the prosecution has no objection to it.
Yes, Your Honor.
All right, and the court, this was based on the record that already exists, will receive in evidence defendant's exhibit S, so marked for identification purposes. All right, Mr. Upton.
The court having received that evidence, given the state of the evidence, the defense would rest its case at this time.
All right, ladies and gentlemen, you've heard Mr. Upton state that the defense rests. This means that the defense has concluded its presentation of its evidence in chief during the trial. Under the law, the parties are given the opportunity to present what is called rebuttal evidence. And so what we'll do is have you, and by the way, I want to thank you very much for your patience this morning. I do want you to know that it was, we were actively working on the case out of your presence, but the rules require that I do that. So at any rate, I do appreciate your patience in this regard. So what we'll have you do is take your lunch recess at this time, return at 1:30, and we'll continue with the presentation of evidence. Rest assured, we're quickly approaching the end of the evidentiary portion of the trial, but that hasn't changed. But the next step in a trial is the opportunity to present rebuttal evidence. So we've completed the prosecution's evidence in chief and the defense evidence in chief, so we're now at potential rebuttal evidence. All right. Thank you very much. So keep in mind all my cautionary instructions, even though you've heard evidence to this point. Again, all of those instructions remain in effect, and that includes not discussing this case even amongst yourselves. Thank you so much. We are in recess.